For the Senate Public Safety Committee, thank you for attending. I see that most of you have already gotten to the sign-up sheet, but if you do wish to speak for or against the bill, please fill it out completely with your information, because we need that for logging the official minutes of the meeting. We're going to have 4 bills on the calendar today, and as promised to my good friend, Chairwoman Ballinger, we are going to have you back first for House Bill 218. We did take testimony on this in the first meeting, so this will be just an opportunity for us. Please sit down and make yourself comfortable. This will be an opportunity to discuss some minor tweaks and changes, and then we'll go with the will of the committee. So, Chairwoman Ballinger, thank you so much for coming, and I know we've got Senator Hatchett here as well, who I believe is going to be your Senate sponsor. Is that correct?
Yes, sir, that is correct.
Wonderful. The floor is yours. Oh, actually, wait a minute. I almost forgot the most important thing. Cardin, Senator Summers, you open us up with the blessing.
Pray with me, please. Our most kind and gracious Heavenly Father, as we come to you today, we ask that you always send your blessings to us, send your wisdom to us, and know that we love you and we care and we thank you for everything we receive from you. In Jesus' name,
Amen. Okay, now we can go.
Okay. The first part of this bill, I'm just going to kind of start from the beginning. I'm presenting to you House Bill 218. I'm working from LC 393012S. So please make sure that you have the most recent copy. The first part of the bill, Section 1, is a universal reciprocity bill. It would allow for universal reciprocity. It would allow our concealed carry permit holders to carry in approximately 5 other states. Section 2 has to do with the emergency powers of the governor, and with regards to the Second Amendment. There are several parts of this. There's also a part with regards to the probate court that I will walk you through. On lines 178, we did add manufacture. I'll go through some of the changes that we made. On 178, we did add manufacture. On 185, we did refuse to accept or give was originally on 185 and refused to accept. So we're not tying the hands of our probate court judges whenever it comes to the issuance of a concealed carry permit, as they do have some discretion with regards to that. Section 6 and Section 7 just go on with regards to the emergency powers, and that is the bill as it stands. I'll be happy to stand for any questions if the committee has any questions.
Thank you, Chairwoman Ballinger. Appreciate all the work. I know that was some confusion, so apologies for having a lot of interested parties who wanted to make some additions, but I do believe we've got a very good and comprehensive solution now. So are there questions from the committee members?
I do have one amendment whenever the time is right, Mr. Chairman.
Okay. Let's do questions. Actually, go ahead and give us your amendment. Just
the amendment will be striking the lines 146 through 150. So we will be striking Section 4 in its entirety. We'll be striking Section 4 in its entirety. That's lines 146 through 150.
Okay. Questions from the committee members? I've got a question from Senator Jackson.
Representative Ballinger, would you be willing to speak to your amendment that you're offering? Can you talk a little bit about why you all want to strike it?
That was at the request of the governor's office, and the administrative floor leader, Hatchett, specifically requested that, and I was amenable to that amendment.
But can you tell me why? Why do you want to strike it?
That would be within the purview of administrative floor leader Hatchett.
Why don't you come on down, Senator Hatchett, and I'll put you on microphone 5.
Thank you, Mr. Chairman, and thank you for the question. This was actually something that was debated. Section 4, as it was written, would prevent the National Guard from shutting down a weapons facility during, shutting down a gun store during, like if we were ever invaded, if we were ever at war on the home front, and we didn't feel it was appropriate to take that power away from them.
Reasonable enough? Why don't you just go ahead and stay right there if you don't
All
mind, in case there are other questions. Other questions from the committee members? Okay, we
great bill.
we reviewed this bill very thoroughly last week in that committee meeting, so I've got a question again from Senator Jackson.
Yes, so can you speak to how do we deal with the fact that some gun laws in other states may not line up with ours? So this law, basically, we're giving reciprocity. So if you come from a state that says that, say silencers are allowed, we would recognize, are we recognizing all of, will we hold them to the same accountability level in Georgia, or would they be held to the same accountability level of the state that they come from?
Georgia laws would still be applicable. This has to do with concealed carry permit holders and the carrying of concealed weapons only. Say, there's a prohibition against silencers, that would be enforced here in Georgia, and it wouldn't affect any of those laws with regards to that. All of those laws would still be in effect.
May I ask another question? May I ask another question? Yeah. How is there a system or a way for police officers, for law enforcement, to verify that someone has a legal license to carry in another state?
They would actually have to contact the issuing authority in that state to verify the correctness of the concealed carry permit.
So
there is no national database.
Right. So if somebody were pulled over, had a concealed weapon with them, then the law enforcement officer would have to call the probate court in the issuing state in order to verify that that license is real?
I'm not familiar with the issuance of licenses in other states. I can only speak to Georgia.
Well, I think I can answer part of your question. So they would have to produce the same license as someone in Georgia would, right? Just as if you got pulled over with your driver's license and you were driving to South Carolina, they're going to look at your license there. If they think that there's fraud or something involved, well, certainly they could do something else, but we have those licenses issued for those reasons. So, okay. Senator Summers, is that you lit up there?
Yes.
All right, go ahead.
Thank you, Mr. Chairman. If I may, Georgia, this is not constitutional carry. This is not a open carry. Georgia's an open carry state. You can open carry pretty much anywhere you want to go. It's pretty much open carry. These licenses that Chairman Bell, I'm just speaking of, I carry one in my pocket. I mean, it's just like your driver's license. So anybody that got pulled over would have their concealed carry license with them at any point in time. And that's basically where we're at. Is that correct?
Yes, that is correct.
That's right. All right, good deal. Thank you.
Thank you.
Okay, other questions from the committee members? Okay, Senator Lee Anderson.
With your new amendment, would that address some of the concerns that probate judges had?
Yes, sir. One of the problems that the probate court judges had with regards to, I believe it's on line 178. Let me just I'm sorry, it's 185. Initially, it said refuse or issue. Was originally the language, and we redacted that back to refuse to accept an application if the building or courthouse is otherwise open to the public. Because the probate court judges had two concerns. Number one, there is some discretion with regards to the issuance of a license, and the second one is the probate court judges often have no control over whether or not the courthouse is actually open. So particularly during the early days of the pandemic, whenever the courthouse was closed, obviously the probate court judge could not be held accountable for not accepting any applications whenever the courthouse is actually closed.
Thank you. Go ahead, Senator.
And just to piggyback onto that, one of the concerns also that the probate judges had was, what about during a hurricane or a tornado? And that also, if the courthouse is not open, they're not gonna have to worry about that.
Certainly. Okay. Senator Anderson.
I'd like to move to amend by striking lines 146 through 150.
I got a motion to amend by striking lines 146, 150 from Senator Anderson. I've got a second from Senator Summers. Is there further discussion on the amendment? Hearing none. Oh, do you have discussion on the amendment?
Yes, I'm sorry. I don't understand what this amendment, I don't understand what this section 4 was trying to do, and So if someone could please try to explain that to me again.
Certainly. I think what Senator Hatchett was explaining to us, and he can chime in a minute if I'm incorrect, is this bill was going to make it similar for the National Guard as it would have been for the governor in order to be able to close gun stores or something of the like. And what the floor leader, Hatchett, said is there was concerns there because let's say we were actually invaded or something had happened, the National Guard might need to do that in order to protect people and lock things down, et cetera. So that was a request by the governor, and it seems to make a lot of sense. So I think that's why they brought the amendment. Does that answer your question?
Yes, thank you.
Other questions for the amendment? Hearing none, we're going to call to a vote. All those in favor of the amendment, please raise your hand. All opposed? Okay, one opposed. Yes, okay. Now, is there any further discussion on the bill as amended?
Mr. Chairman, since that amendment passes, I have a further amendment to clarify
Okay,
the underlying bill.
all right.
On the title.
Hang on one second, let me. All right, Chairman Harper, go ahead.
Just for clarification purposes, since that amendment passed on the title, we want to strike line 15 in its entirety and strike line 16 up to the word order, including the semicolon. And we would like to renumber the rest of the bill accordingly. Is that a fair amendment?
All right.
This is just for conforming purposes for legislative council, so we're striking line 15 in its entirety and striking on line 16 from disorder to the word order, including the semicolon, and renumbering the rest of the bill accordingly.
All right.
And all that's for conformity.
All right, so I've got a motion to amend from Senator Harper. Do I have a second? Second from Senator Anderson. Any further discussion on the second amendment?
Yep.
Hearing none, all those in favor, please raise your hand. All opposed? Okay, passes. Okay, any further discussion on the bill as it has been amended? If not, I will entertain a motion for a perfected committee substitute. I'm sorry?
Is there community members here to speak to them?
We actually took testimony on this in the last meeting, but we will do that on the bills that are new for this time. All right, so I've got a motion from Senator Summers for a perfected committee substitute. Do I have a second? Second from Senator Payne. Is there further discussion from the committee members? Hearing none. All those in favor, please raise your hand. All right, 1, 2, 3, 4. All those opposed, like sign. 1, 2, 3. Passes 4-3. Thank you, Chairman Ballinger, and I believe Floyd Hatchett will be your Senate sponsoring carrier, correct?
Yes, that is correct.
Wonderful. Thank you for your time and
Thank you,
all
Mr.
the
Chairman, and members of the committee.
effort. Thank you. All right. Moving on. Next, we're going to do House Bill 168. Come on down, Representative.
Okay, if I take my mask off to
Please
speak,
do.
Chairman,
That's
that's
fine.
much more comfortable. Thank you very much for having me here today. And I'm ready when you are, sir.
Go ahead and take us away. Just want to make sure everybody knows we're operating off of LC 412678, and I believe your Senate sponsor is here as well, Senator Watson. So
He is. Senator
right,
Watson,
continue.
my good friend, will be carrying this bill, assuming it is favorable to this committee. Mr. Chairman, let me begin by just telling you kind of a brief story about why I've been engaged on issues like this for some time, and certainly with this measure that's before you today. I'm going to tell you just real quickly a story that I told to the House members on the floor, a story of a man named Torrey Scott that will resonate very powerfully with Senator Watson, an individual who is released on parole, and while paroled, just wrought havoc in our community down in Savannah. previously convicted of a violent crime, released, sets out, rapes 2 young ladies at Savannah State University, rapes 2 young ladies there, destroying their lives. Subsequently kidnaps a nurse at the Candler Hospital parking lot, rapes her, tries to kill her, she escapes. And then after that, finally he rapes, kidnaps, and murders a woman in Port Wentworth, right outside of Savannah, while her young child is in the home and while her husband is overseas serving his country. We have a problem in our society, and the problem is that our recidivism rate for violent felons is abysmal. And so we've got to be careful when we release violent felons. And I want to make it very clear, this bill that's before you today only relates to violent felons, as I'll show you in a couple of moments. We parole about 10,000 inmates a year in this state through our Board of Pardons and Paroles, and their representative is here today. They support this measure. Well, we parole about 10,000 inmates a year. This bill is targeted to only the most violent of the violent. And so what this bill does, before I get into the detail, just 30,000-foot view is very simple. Our district attorneys already have a right to be notified before an inmate is released back into the community in which the crime occurred, as does the victim, the judge, and the sheriff. They have that right, but they don't have a right to have access to the correctional record of the inmate while he has been incarcerated. That is, believe it or not, a state secret. And most people, when I tell them that, they look at me like I've got horns growing out of my head. They don't understand why it would be a state secret. But it is. And that's what this bill does. This bill removes that state secret status from the correctional records for only those inmates that are circumscribed in this bill who are violent felons, and I'll point that out. And it does only for district attorneys. So this doesn't make that information available to anyone other than the chief law enforcement officer in any jurisdiction who sentenced that inmate for a violent crime. And now that inmate is being considered by the Board of Pardons and Parole for parole, which means they're going to truncate that sentence, and that individual is going to be released early. I would remind all of the committee members what I know you already know, and that is that parole is an administrative process. There is no right to parole. Parole is clemency. It is a privilege. There is no right to parole for any Georgian. And so let me begin, Mr. Chairman, if I could, just to speak to, if you'll look on page 2, on line 18 and line 21, you'll see precisely the crimes that are dealt with here. Only those things that are dangerous sexual offenses against minors. And you'll see the language there. Mr. Chairman, I have with me the 19 crimes that in statute are called dangerous sexual offenses. I'm welcome to share these with the committee. I will tell you they are the most heinous, violent, sickening crimes one can perform against children in society. So that is what is on line 18. On line 21, this bill relates to serious violent felonies. The serious violent felonies are what we often refer to as the 7 deadly sins. That would be murder, rape, armed robbery, aggravated child molestation, aggravated sodomy, aggravated sexual battery, and manslaughter. So we're only talking about inmates who have been convicted for these crimes. Okay, now if you move on down to line 26, what you see is the meat of the bill, which is removing that state secret status for district attorneys when individuals have been convicted of these crimes I just alluded to. Further down the bill, Mr. Chairman, on line 32, you'll see that this only relates to data that is available from the Department of Corrections beginning January 31st of 2010, and that is expressly in order to gain the support of the Department of Corrections, which we have, because they went to a new system, electronic system of keeping their records, which began on January 31st of 2010, a system called Scribe. And then, Mr. Chairman, a real important piece of the bill, on line 47 through 50, you will see something that I added trying to get everyone's. My hope was that with a matter like this, my thought was how could anybody be opposed to such reasonable transparency? But in an attempt to try to get everyone's support, I added line 47 to 50, which does this. It makes it very clear this information is only for district attorneys. It cannot be shared, and indeed added a misdemeanor crime that does not exist today, that if it were to be shared inappropriately, that would be a misdemeanor. This bill, Mr. Chairman, is an issue that I feel passionately about because of what we've experienced in my community with violent crimes. Violent crimes in our community tend to be committed by violent criminals who have proven themselves to be violent over and over and over again. And this is an attempt to add a little bit of transparency to a process that is not very transparent. Mr. Chairman, I'll stand for any questions. Glad to answer any questions the committee may have.
Well, thank you for bringing this bill forward, Representative Petrie. I do have a question, and then move to Legislative Council, actually. Today, what is the crime that would be charged for divulging a state secret? Do you know that off the top of your head? Okay, I want to make sure that we're not lessening it by putting this in here.
Yes, sir.
So if we could, is there any way you can pull that up on your computer? All right, well.
Thank you,
while
Chairman.
we do a
I
little searching,
appreciate
we're
that.
We're gonna look through that. Questions from the committee members? Got a question from Senator C.
Thank you, Mr. President. I just have a curiosity question. Parole, you said 10,000 per year, so how many are you arresting?
Ma'am, how many are we arresting? Well, I don't know how many are arrested
Violent.
a year, violent
'Cause we're
felons.
talking about,
But close to 10,000, and the parole board is here. They may speak better to it. We have 10,000 inmates a year who are released early on parole. Senator, that's the information that I have.
one last follow-up. Mr.
Please, go
Chairman.
ahead.
Yes, ma'am.
And what did you call it early? I know the parole thing, so you're saying less than what they were originally doing.
Yes,
But
ma'am.
Any, well, I guess.
Yes, ma'am. That would be any of them that are released earlier than a jury of their peers sentenced to them in their community in which the crime occurred.
Other questions for the bill's author? Senator Summers?
I like this. Thank you for bringing this forward.
Thank you,
Why
Senator.
would we not include judges and DAs in case you had to have that communication right there?
Senator, good question. I don't know. I haven't really contemplated that. I work very closely. You know, as a chief law enforcement officer of the community, that district attorney, I felt like needed to know. They have a right to object. And by the way, the parole board doesn't have to even read that objection. But the district, I would hope that they would, but the district attorney has now a right to object. And what we wanted to do, you know, it seems pretty commonsensical that how you behave today is a pretty good indicator of how you're going to behave tomorrow. And it seems like in order to make that objection, it would be helpful to know how that inmate is behaving. And so I can't answer. I think it's an excellent question, Senator, but I don't know that I can answer it any better than that. My goal was to see that that district attorney had this information, but excellent question, sir.
Got a question from Senator Jackson.
Yes, ma'am.
Thank you for bringing this bill. So I just want to make sure I'm understanding. The DA would receive essentially the person who's incarcerated, their record of what they've been doing while they were incarcerated.
Yes.
That would still remain a state secret, so the DA would have to keep that information to themselves.
Yes, ma'am.
So then, if they were to go to submit a written objection to the person being allowed out on parole, what evidence would they be able to cite to say that they should not let that person out on parole?
Yeah, Senator, good question. So, and that's helpful for me to be clear. So the parole board does have this information. So the objection is being made to someone that already has the information. So the issue is that the parole board has it, but no one else does. And so my goal is to bring transparency to the process by at least letting that one person that is most charged with protecting a community be aware of how that inmate is behaving. But very good question to help me clarify that.
Can I
Thank
ask
you.
a second question?
Yes, ma'am.
Would you be open to allowing that inmate to also receive that information?
Well, Senator, we can't do that, and here's why. I had a lot of conversations with the Department of Corrections on that. So here's what happens, because I want to make sure I'm real clear on this. The inmate already has these records. So the inmate, whenever there's an infraction, this is what I've learned from parole and corrections. When that inmate has a behavioral issue, he is immediately given a written report. So he has received anything in writing that relates to his behavior while in prison. What we are not doing here is giving him the exact, complete record that we're providing to the district attorney, and that speaks to your question, and that is because of this. In that record, we have names of officers, we have informants, and so the Department of Corrections taught me very early that that information cannot be shared, because if it were to become public, and there'd be no quicker way to make it public than to give it to an inmate, that information would jeopardize our correctional officers and others who help us to keep the peace in these prisons.
Certainly. So would you be open to an amendment in which we redact that information, any information that would compromise a department employee or an informant?
No, ma'am, I would not, and I'll tell you why. The department believes that would be impossible. In other words, to redact the enormous volume of data, and then, moreover, to be confident that you caught it all. In redacting all of the information that might be sensitive, the Department of Corrections would be very opposed to this bill. They support this measure, but the Department would not support that amendment, Senator.
So basically what we're doing is if we pass this, we would be allowing the DA and the parole officers to have, full access to information about a person, but that person themselves wouldn't get to know what information those people used against them.
Senator, no, ma'am, that's not correct. So not parole officers.
The parole board.
The parole board alone is going to be aware, and that district attorney in whatever jurisdiction, it is correct that they would have it and the inmate wouldn't. But again, I'll speak two ways to that. Number one, the inmate's already received all this information. Remember, the DA is trying to discover how an inmate has behaved in prison. The inmate already knows how he's behaved in prison, and the inmate has already received a written report on any infraction. The DA doesn't have that. Second issue is this. This information, I was going to say something else to that. I think I wanted to add one other thing to that. So the inmate already has it, and there was another thing, maybe it'll come back to me, I was going to add. I might, thought I had two things to say there.
Thank you.
Yep. Yeah, I forgot what it was.
All right, we've got some more questions here. First one's going to be from Senator Robertson.
Yes, sir. Senator?
Mr. Representative, I apologize for running in late. I was at another subcommittee talking about second chances for inmates. But so I may ask you a question that you've already explained. But is the purpose of this to use in a hearing to determine whether an inmate should be released? As far as the information to the DA, what is the reason, the common reason you think that the district attorney would want the information?
Yeah, the district attorney would want this information. So if I were a district attorney and I represented Chatham County, and you were going to release a Torrey Scott, the story that I gave earlier.
Yes, sir.
I would want to know that before you did so, I at least did my duty to let the parole board know that this inmate convicted a heinous crime or crimes in my community, and that also he's not behaving well in prison today. And I'll give you a good example of that, Senator. Actually, you reminded me of something else that there's another story. We recently had, this will speak to your question. We had an individual named Fabian Wright recently in our community who was paroled early, immediately arrested for, again, another assaulted rape on a college student at Savannah State University. And guess what was discovered after he was arrested again? He had multiple forced sexual acts in prison. So if I were a DA, I'd want to know how an individual was behaving. And the answer to your question more fully is this. All that DA can do is say to the parole board, I hope you'll hear my voice. This individual created great harm in our community, and it appears he's also not behaving well in prison. The parole board doesn't have to even hear it, doesn't have to look at it. The parole board acts with complete autonomy in this state.
That's correct.
Okay, and so there is no transparency. This is an attempt to put a sliver of transparency in a very, very untransparent process.
No, and I appreciate your explanation and everything.
Yes,
and I
sir.
think it was, my question was, is the purpose of it as they're reviewing the individual for the opportunity to be released on parole? And,
Yes, sir.
and so
So-
that's it. So basically
Yes, sir.
what we're offering the DA, and my friend across the way will correct me if I'm wrong, is basically discovery to use during the hearing on whether I get letters throughout the years from the parole board saying somebody's up for parole, and if I want to send letters or whatever,
Yes, sir.
then I can do that. And what we're doing here is giving the district attorney discovery from when that individual was incarcerated based on their behavior. So using the sex offender, it would have been a great argument for he or she to go in there and say, hey, look, this conduct has not changed since the individual's been incarcerated, and my job is to protect my community, and thereby I think they should stay inside until
Yes,
their
sir.
full sentence is complete.
Yes, sir. And what I've learned, Senator, very good point. What I've learned as I've worked on this issue now for years on different measures related to this, what I've learned is this: there are a lot of things that happen disciplinarily in prison that aren't, because some of the questions were, well, aren't they charged with new crimes? If that's the case, no, they aren't. There are all kinds of forced sexual acts that occur in prison that are never prosecuted as a crime. And so that information, one would think, if you're trying to protect the community against violent sexual predators, it might be helpful for that district attorney to have that information.
Yeah,
no
and
one
just-
else.
just
But
point
yes,
of
sir.
clarification,
But it
that-
is related to parole, yes, sir.
Yeah, but
Yes,
the
sir.
Department of Corrections is obligated under federal law to report sex crimes and reported sex crimes while people are incarcerated. I just want to make that
Yes,
point
sir.
clear. Yeah.
Thank you, Senator.
Yes, sir.
Thank you.
Okay, we got some more questions. We have some more questions. Senator Harold Jones.
Thank you, Mr. Chair. So the parole board would have this information now?
Yes,
without
sir,
this
Senator.
law.
Yes, they already have it, Senator. Correct.
And the inmate has this information, but it has redactions.
Yes, sir. The inmate has the information without redaction. He gets it from the correctional system. But again, he gets it kind of on an ongoing basis. Whenever there's an issue, I'll use the term when an inmate is written up, the correction says he gets a written report. What this would be the entire record provided to the district attorney if they request it, by the way. It's not just going to automatically go out. But a DA that says, I want to see the record on Torrey Scott, he would be provided with that information, he or she, but it would be the complete record. So it's going to be some different than what the inmate has received kind of collectively over his time of service.
If I may, Mr. Chair.
Please.
And so
Yes, sir.
then would the DA now be notified that this inmate is coming up for a parole hearing?
Yes, sir.
So they get that notification?
Yes, sir. They have that right that is currently in statute. And Senator, also the judge, the sheriff of the county, the DA, and the victim. Those are the folks that are notified before an individual is paroled.
And so this is giving them information that you may want to go to this hearing?
It really gives them information to simply write a letter of objection if they choose to the inmate's release. I guess more fully, they could pursue it more fully if they chose to. Yes, sir.
I guess the design is to let them know you may want to write a letter of objection based upon what this person has done.
Yes, sir.
Because maybe they're
Yes, sir.
not doing that as much now.
Yes, sir.
Okay. All right, thank you.
Yeah, thank you, Senator.
I've got a question from Senator Lee Anderson.
Thank you, Representative, for bringing this bill. Did I just hear you say that if a criminal commits a rape while he's in prison, he's not charged for that?
Well, Senator, so my understanding, again, not being an expert in these affairs, but as I've learned over the years studying this issue, is that there are people charged with crimes while serving time in prison, but there are oftentimes things that happen that aren't necessarily adjudicated. But there are a lot of misbehavior and forced acts, as that which I just described earlier, that never are fully charged. They aren't fully charged with those crimes. That's correct. Yes, sir. That's my understanding from corrections. And I don't know if they're here today. I know parole is here.
A question from Senator Jackson.
So thank you, Representative. You explained that the Board of Paroles already has this information about the inmate.
Yes, ma'am.
It's already been provided to them. So the Board of Pardons and Paroles is charged with making this decision with the information that they have in front of them. Is this in some way Is this trying to say that the Board of Pardons and Paroles has not been doing a good job already?
No, ma'am. Thank you, Senator. Here's what I would say to that. So if 5 men and women, which comprise the parole board, are releasing 10,000 inmates a year early, by the way, in contradiction to the jury of their peers that sentenced these individuals, it would seem to me that a little bit of transparency and help from our DAs would be helpful to them. But here's what I can say. So I'm not saying that they are failing. What I can tell you is there have been many failures. I just started my conversation with a horrible failure with 4 women who, one of which is dead, the other 3 will never be the same again, all because of an individual released early. So are there failures in this system? There are many, many, many horrible failures in this system. That is correct. And I think transparency is always a good thing, and it's certainly a good thing here. This gives it a little bit of transparency to let that one person that you can trust is not going to just release it, we even make it a crime to do so, that they can speak up in trying to protect their community.
Thank you.
Other questions from the committee members? Okay, we've got Jill Travis here. Why don't you go up to the podium if you don't mind?
Well,
And
that's a quick move on my part. Thank you.
go right ahead.
Good afternoon, members of the Public Safety Committee. I think this is the first time I've appeared before you this year, and it's a pleasure to be with you. My name is Jill Travis. I'm the Executive Director and a Policy Advocate for the Georgia Association of Criminal Defense Lawyers. I stand before you concerned about House Bill 168 and what it might do in terms of leveling, or rather unleveling, the playing field. As has been mentioned, the information from the Department of Corrections is in the hands of the parole board at the time they consider someone for parole. Contrary to Representative Petrie's statements of support by the Board of Pardons and Paroles and support by the Department of Corrections for this bill, it is my understanding that they remain neutral on these bills. With respect to the way the world works in terms of somebody being accused of a crime, as you know, somebody gets arrested for a crime and they're prosecuted, and that's the charge of the district attorney or the prosecuting authority. The difficulty is, or the way the process works, is the accused is giving the evidence against them, the statements. They don't go to the police department and get the police reports. They don't go to the witnesses and get the witness statements, the copies of it. The prosecution provides the discovery in the process. So in the same vein, when we're talking about the parole process, if the district attorney is going to have access to this information that comes from Department of Corrections, we would like to have the person who's accused and who's going before the parole board to have access to the same information. I agree with Representative Petrie that they have been given a copy of their disciplinary report when it happens. The folks that are under consideration under this bill have been in custody, many of them, 10 years. I've read the Department of Corrections policies with regard to what inmates can keep in their possession, and it's very limited. So yes, they may get the initial report that they have been cited for a disciplinary report. They may get the findings that they were found not guilty of the disciplinary report, but whether they keep up with it is another matter. Whether they can keep up with the positive things they do, and I'm not saying that you should feel sorry for the person for not being able to keep up with it, but it's not like you. It's not like you have some important folder that you keep your documents in. These are people that are in custody. They don't even have the access to make a copy of the document that they could send to their lawyer to help them. The only thing they can do is send the document home, which at the time, they may or may not know the importance of that document 10 years down the road. So under this bill, we're tilting the table so that we allow the district attorney to comment and have information but we don't allow the defendant and the inmate to know the information. Let me give you a specific example of one of the cases that came to one of my members' attention. She had a client that was accused of and written up for being a gang member. It turned out that he was listed as a gang member because he was raped by a gang member. The person who raped him used him to get into a gang. But the wrong information got into the inmate's folder, now in the hands of the district attorney, and unable for the inmate to counter that because he doesn't even know about it. And because they are state secrets, I'm not quite sure how any information about what is in the Department of Corrections files are getting out to anybody because they are supposed to be state secrets. This particular information came into the attorney's hands that I'm talking about through a case, a civil case. So it was through court records that it came out. But the dangers are to just leave it on one side and not have the other side have any information to be able to rebut it. I would ask you to consider amending Representative Petrie's bill so that the district attorney, whatever information is provided to the district attorney, be provided to the inmate who's under consideration, and that the information be redacted having to do with department employees or confidential informants, and that the inmate suffer the same consequence of punishment of it being a misdemeanor if he were to release that information to the public. And I have a proposal here. I'm gonna, I think I have enough copies for the members of the committee, so may I pass that?
One moment. We'll have someone come to you.
Okay, thank you.
Okay, anything else that you would like to mention? If not, I want to give the committee members a chance to ask a question if they have any.
I'm finished.
Okay, I've got a couple questions. Senator Jackson.
Thank you so much. Can you, so if a person is accused of a crime outside of a prison situation, then they can have an attorney and it gets adjudicated, right? There's somebody who defends them ostensibly, and then there's somebody who prosecutes them. But if someone were to get written up in prison, do they have someone who represents them to prove or to help say that, no, they're not guilty of that thing that they've been written up for? I guess what I'm concerned about is it possible that someone could be written up in prison for something that they actually didn't do and that remain in their record? Is that possible? Does that happen?
I have to tell you, I'm not intimately familiar with the Department of Corrections process. I mean, certainly there's not a right to counsel in the process, but the example I've given you of somebody being having a mark in their confidential information that they're a gang member when in fact they were a victim is the perfect example. I can't give you a line and verse of how many times that happens, but I suspect that was a very innocent mistake. I don't think that the Department of Corrections meant any malice for it. But the fear is that information gets into the hands of the district attorney who doesn't know that it was a mistake. And then the inmate doesn't have any way to counter that because they don't know what's in the hands of the district attorney.
I've got a question from Senator Robertson.
Good afternoon.
Good afternoon, Senator.
Really quick, and I apologize if I jump around on your testimony. The situation you spoke of where the individual was identified as a gang member in their file after they were sexually assaulted by an individual for the purpose of getting into a gang. Do you know if there was there a PREA report done on that?
No, sir, I don't know what PREA is, and I'm not familiar.
Okay. And the Department of Corrections, to my knowledge, has a policy on discipline to where if an individual, and listen, we're not talking about crimes, we're talking about infractions.
Correct.
If a person commits an infraction, whether it's, you know, doing just some general disregard of a rule of where you walk or where you're not supposed to go and things of that nature, then they can receive a I think there's a little acronym for the form they receive, an infraction document, and there's opportunities for them to appeal that in the
Yes, sir.
policy that I've read, where they could go up and explain what the circumstances are and things of that nature. But to your comment of leveling or unleveling the playing field and tilting the table, would you agree that the discovery allowed where I go out and commit a crime in the free world and I'm arrested and I hire you to represent me, if I could afford you, and we got into court, that the DA would have to give you discovery of all the information, evidence they have against me, and we would be able to use that in order to build our case and hopefully get me exonerated in front of a jury of my peers or a bench trial or something of that nature, correct?
Yes, sir.
So at a parole hearing, there has been no accusation of a crime. At a parole hearing, what we're trying to determine is if that individual has been, and I use a word that several of us around the table have an issue with, if I have been rehabilitated enough to go back out into the community. And some of the information that can be provided is my behavior while incarcerated. But in some of the hearings I've been into, the inmate, have an opportunity to explain how my time in prison has been. My victim's family have an opportunity to come in and explain that they feel me getting out early may not be me paying the debt that they feel I should pay for whatever crime I've committed. And also the district attorney, who's responsible for the safety of the community, but also in some cases the inmate can have, you know, if there's somebody that's really tied into he or she's incarceration, such as a chaplain or a counselor or somebody like that, they can petition to have them go also, so that this is not just a, me as a convicted citizen of the state of Georgia, convicted of a crime, walking in front of this big, massive wall of angry people who don't want me to get out. There are big differences in between what we do in a court of law to determine the guilt or innocence of an individual and what we do in a parole hearing to determine if an individual has reached a point to where everybody feels comfortable with that person integrating themselves back into the community. Would you say that's not true?
I would not agree with you on that
Okay.
specifically.
Well,
if I might elaborate, sir.
Oh, sure. And please do me a favor, elaborate into, if you will, how due process in the district attorney's office is alike the due process in a parole hearing.
The parole hearing is a neutral body that's going to consider whether somebody should remain in custody or should be given the ability to prove themselves in the outside world. Whether they and most of us, I think, would agree that we want people to have some period of parole. We don't really want to be 25 years and walk out on the streets without having somebody by their side to help them and be with them and lead them down the right path.
That's right.
So you've got the parole board that's the neutral that's hearing this case for consideration. There is, and we're using, for purposes of this conversation that we're having today, we're saying the parole hearing as if there is actually a hearing, just like we're having today. We're having a hearing. And but to the best of my knowledge, there isn't actually a hearing. Most of what is done is all done on paper. So it's submitting the paperwork. It's not as if we're in a room and the DA says, that man was involved in a gang and blah, 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 and the inmate standing there is like, but no, not me. I wasn't involved in the gang. That was a mistake. It doesn't happen like that. And what you're allowing the prosecutor to have access and to give their arguments as to why this should not happen the way he claims that it did, without the other side knowing what's being said, without the other side knowing what's involved. Now, Inmates are sometimes represented by counsel, and sometimes they're not represented by counsel. To the same point of now the district attorney is going to have access to this information, counsel for the defendant is not going to have access to the information. So they're not the same. And I mean, and as you know, some people do
So real quick,
rehabilitate like themselves, like the plumbers.
Well, real quick,
know?
I want to clarify. You just said they're not the same. And that was my point. They're not the same.
Court and parole are not the same. Yes, sir.
Correct. The rights that are provided to myself when I'm out are very different to prove my innocence. Nobody's accusing a parolee. Nobody's trying to reconvict anybody in those hearings and I participated in the hearings and in the mail-ins of individuals that have killed members of my family. And so sometimes we write letters, sometimes we go sit in hearings. But my point is they are very different. Therefore, the tipping of the table and the slanting are not the tipping of the table and the slanting that can and has occurred in superior courts while someone's there charged with a crime. But I'm not being counter to what you're saying. You made a lot of good points. None of us want anybody to stay in there 25 years and to walk out into a world unprepared for what lies out there. But my point was the rules in one are not the rules in the other.
I can't disagree with you on that point. Certainly there are different rules. In my world, fair is fair, and that's what I'm trying to get at. I'm trying to make the point of the fairness should be leveled.
Thank you.
Okay, any other questions for Ms. Travis? Thank you so much for coming.
Thank you.
That is the only person that signed up, but I'm going to take a look at the audience for a moment and ask if there's anybody else who wants to say something on this bill. Okay, seeing none, we'll bring this back to the rest of the committee unless you want to make any closing remarks, Representative Petrie.
Chairman, I would just to tell Senator Robertson how helpful his comments were. He just very eloquently explained, I think, the root of this. There is a fundamental misunderstanding here. This is a procedural matter. This is not, as you described so well, an inmate being convicted and tried. This is a separate procedural matter regarding expressly just parole. And so I think that some of the folks that are pushing back on this are seeing this through the wrong lens. I would remind everyone here, lastly, just this. Remember, our DAs come and go. That DA that 10 years ago convicted this individual is no longer in office. And they don't know all the nuances about this individual. This will give them some information on how that individual is behaving today, which absolutely is relevant to how they might behave tomorrow when they're back on the streets in our community. But thank you, Mr. Chairman, for allowing me to hear this today.
Thank you. I've got a question from Senator Summers.
Representative Petrie, just straight out.
Yes, sir.
If this legislation was passed before that inmate you spoke of got out and raped with 3 or 4 different individuals, would having passed this bill save those people?
Well, so here's what I would say. If an inmate has been released early while misbehaving in prison, there might be a chance that just maybe somebody noticed that behavior and called it to the attention of the parole board, who happens to be paroling 10,000 people a year, 5 individuals, okay? And that it just might help us to parole individuals that created that calamity. Yes, sir. But I wanted to phrase it that way to be precise. I don't want to overstate it. This isn't the degree of transparency some might want. This is a tiny little window of opportunity for a little bit of transparency for the people, to protect the people from violent, heinously violent felons that I circumscribe in this bill. Thank you, Senator.
I do want to clarify, thank you to our legislative counsel, that on lines 47 to 50, the same language applies for the parole board already. That's a misdemeanor, so this would be exactly consistent, so thank you. I do have a question from Senator Harold Jones.
Thank you, Mr. Chair. Just one. When the DA receives this record, are they then able to, when they file their objection, point to like instances within this record to support their objection?
Yes, sir, Senator. I would think that they could. They'll have the information, so they might, and if they choose to seek it, because maybe it's a high-profile case that where there was a great deal of violent crimes committed for this particular inmate, they might look at that and discover some things that they believe should be pointed out to the parole board. Yes, sir, and they might expressly allude to some of those things. Yes, sir.
Within that prison record, they can expressly allude to. That's what we're saying.
Yeah, they could use that information in their objection to the parole board. And by the way, I would also add this. Remember, the district attorneys also can write written support for parole. And they do that as well. There may be individuals, they say, listen, the guy's been a record inmate. We support this individual. It just gives them a little bit of information about how that inmate has behaved.
Thank you.
Okay, I don't see any other questions, so we will go to the will of the committee. I have a motion to pass, and I have a second from Senator Summers. I've got a light on those, so I'm going to guess there might be a potential for an amendment coming from Senator.
It's not a potential for amendments. I just wanted to speak to the bill when I had an opportunity.
Okay. All right. One moment, please. We've got a motion and a second. Now we'll do discussion.
Okay. Thank you, Mr. Chair. I can see the issue that the district attorneys are having and the parole board is having. At this point, I'm still not in favor of it. I understand exactly what's going on. The district attorneys are saying, look, we had information. If we had this information, we could actually be able to point out and possibly, they're actually trying to weigh it against the person receiving parole. I get that, and it is important. But the problem, I think, is that, and when that was clarified, that they can point to the record. Now I have a trained lawyer pointing to a record against potentially a layperson. That part concerns me. And therefore, I think that there has to be some way within this bill. There's too many smart people dealing with this, and I honestly mean that because criminal lawyers are the smartest ones that can actually figure out how to balance that out. And that balance is not there. And I think the whole purpose of it to some extent is to try to kind of weigh out against the person being released. And I would state that if anyone has committed those type of heinous crimes, I would hope our parole board isn't releasing them. They have that information. So I think that balance against is going to go to a close case, so to speak. If I have somebody who's committed rapes in jail, I hope that the parole board isn't running around releasing them when they're not part of a gang and there's no question, because they have this whole record. So I'm assuming they're doing a good job there. I think the way the scale is going to turn is going to be in that closed case where the parole board ordinarily would say yes, but now they have a district attorney saying objecting. That's going to influence them on some level. I'm not in favor of giving this to an inmate who's committed a violent crime. I understand that it could be redacted, and I understand that, but a misdemeanor punishment would not be enough. So I would not be presenting that particular amendment. One of the ways to maybe resolve this is where that person, if a DA is going to get involved, and that person receives legal counsel, and that legal counsel has the same obligation that the district attorney towards secrecy. However, they can work that out, and I don't know if we could do that now. But the fact of the matter is, and that legal counsel would understand that their bar license is on the line. And if they're willing to give that up, that's on them. But I would never want to give that information to a defendant who's been convicted of a violent crime either. So to me, I see it and I think it's a good idea. I'm just not sure it's quite ready. If it was in front of us in January, Mr. Chair, I'd vote to move it on and we could continue to fix it. But being where it is today, I would be opposed to it.
Thank you, Senator. I've got Senator Robertson next.
I do have one concern, and as to what happens with the record once the hearing is over. I would not be comfortable knowing that a DA's office was given a file from someone in the Department of Corrections and it possibly be retained and held on to. Something as sensitive as the information that we talk about that then in cases involve other individuals, possibly if there have been other crimes committed in jail or other actions or informants redacted, not redacted.
Senator, mash your button again. You're going off.
There we go. Well, I think everybody heard me is my primary concern, is something that we may need to look at is some kind of custodial requirements or a requirement for the record to be destroyed once the hearing is over, just to protect all the parties involved, including the inmate and any possible victims or any suspects if there were any crimes committed against the inmate that might be contained in that file is something else that I think for consideration.
Senator, I'm not an expert in this field, but my guess is it would be similar to any PII, personal identifiable information that a district attorney has, at which point they would either redact, destroy, or what have you, right? Because they have a lot of documentation under their purview that is never meant to be for the public to see, right? From everything from identity theft to anything else. So I have a higher degree in confidence probably that that's already handled under their office and their procedures, perhaps.
Yes, sir. And I know the state has a schedule, but then again, the schedule pertains to criminal records of cases prosecuted by the DA's office. And this is kind of a unique, I feel, record, but I understand what you're saying. That's just a concern I have, is just that information, what happens to it afterwards.
Okay, thank you. Other comments from the committee members? Okay, seeing none, I have a, do we get a motion a second, right? We have a motion a second. All right, any further discussion? Sorry, it's been one of those days. Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4, 5. All those opposed, like sign. 1, 2, 3. This passes, and again, we've got Senator Watson as your Senate sponsor. Thank you. We appreciate it. Have a good day. And we are going to run out of time, so we have to go pretty quick here. Representative McDonald, I think yours ought to be pretty darn quick, so why don't you come down and don't talk us out of it. Brevity will be your friend.
Yes. Thank you, Mr. Chairman, members of the committee. Sir? Oh, I'm going to be very quick. We're going to change one word. This is House Bill 453, LC 392828. Basically, this is a firefighter tag bill that if you'll look at line 14, that it strikes personal and turns right past that, purposes unrelated to the roles of firefighter. What this is saying is I want to use myself as an example, is I have my personal vehicle is owned by my funeral home. I cannot put a firefighter, I'm a retired 27-year retired firefighter. I cannot put my firefighter tag that's assigned to me by the tax commissioner. It goes to the individual. It doesn't go to really a car, even though you put it on a car, or it doesn't go to a corporation. It is assigned to an individual. I cannot put it on my car that I drive every day. My firefighter tag is in Tennessee on a car that I do own that my son's in boarding school driving. He drives all over, up down the road with a firefighter tag on it. Same as a firefighter if he owns a lawn company that goes to work one day and is off two, that he cannot put it on his truck that he may own by his LLC. So that's basically the gist of this bill. There was some lead council cleared up a few things, changing local tag office to issuing county tag agent. Also, they cleaned up a part about a retired firefighter. They don't have to go every year back to a chief and get a letter. They're going to attach with with computer systems today, put retired by the retired firefighter. So always, as a retired firefighter of 27 years, I always want everybody to remember that firefighters save more than homes. They save hearts, memories, and dreams. So I hope I get favorable consideration on House Bill 453.
I'm looking at my friend Senator Randy Robertson, and I'm afraid what he may ask you after your last comment. But go ahead. Just remember, he's a police officer, so you have to talk.
We'd save them too.
Yes.
Oh, did I say that out loud? Yeah. Golly, I'm sorry.
Yeah, and you were doing so well. Now this tag, yours. Now,
Order.
Your tag, displayed on the tag, is it a volleyball or a pot of chili? What do they put on firefighter tags?
You're out of
so that we
order.
know?
You're out of order.
It is chilly.
Okay, thank you.
Senator Jackson.
When the time is appropriate, make a motion to pass.
Is there, all right, before that happens, are there any other questions for the bill's author? You have a question, Senator Anderson?
Is this your first bill?
In front of y'all, yes, sir. And after the speech I heard today, I was scared.
Yeah, well, you probably should be. All right, I've got a motion from Senator Kim Jackson. I've got a second from Senator Valencia C. Is there any further discussion by the committee members? Hearing none, all those in favor, please say aye. Aye. All those opposed, please say no. Passed unanimously. And who's going to carry this wonderful bill for you?
There is a chairman of the Public Safety Committee in the Senate that I love very much. A neighbor of mine is going to be carrying this for me. Thank you, ladies and gentlemen, Mr. Chairman.
Appreciate it. All right. We're going to move on to the final bill. Representative Collins, we've got House Bill 364. You sat here so patiently.
Yes. Thank you.
And we are pressed for time. People getting in this room, so brevity, please.
Thank you. House Bill 364 is a very simple bill. What we're doing is we're saying that if you're a post-certified officer and want to be a security guard here in the state of Georgia, that we're going to give you 60 days once you are employed by a private security company to get your certification. If you are also a post-certified, you also are exempt from the 2 fingerprints that the Secretary of State currently requires. The thought process behind that is, if you're a post officer, you've been vetted. You know, our post council here in Georgia has the largest. What am I saying here? I guess it's the strongest standard, and we withdraw those certifications from officers more than any other state in the union. So that's basically what the bill does. Very simple.
Makes perfect sense, and I know it'll help our officers out in the other jobs that they're doing to help supplement their income. So,
Yes, sir.
With that in mind, I see Senator C raise her hand. Is that a motion? It is a motion. All right. Is there any questions before that? No, I got a second from Senator Robertson. He beat you to it. Any further discussion from the committee members? Hearing none, all those in favor, please say aye. Aye. All opposed, please say no. Passed unanimously. And who is carrying this bill for you?
I haven't asked anyone to do that.
Okay.
Mr. Chairman, you want to help me with that?
I would be happy to help you out on that. Thank you. Actually, you know what? I think it'd be more appropriate that we have a retired law enforcement officer, if that's okay. I'd like to ask if we could have Chairman Randy Robertson do that. Would that be all right?
I would be forever in his debt.
Okay. I think that would be most appropriate. Thank you. Okay. Ladies and gentlemen, thank you so much for your time today. This meeting is hereby adjourned.